Yes, Mr. Spink. The court clock is now in alignment
Yeah.
with the rest of us.
Thank you. I'm going to just, you may recall that my Lady Justice Asplin asked me where in the judgment the judge got it wrong in relation to the methodology that's used in the in Rule 21, and there is a place where we submit that he got it wrong, and I'm sorry that I had a momentary lapse of reason when you asked me that question. The paragraph is paragraph 99. Where his third reason for construing Rule 21(1) 1 and 2 effectively, this is under the heading of 21(1) 2, but would presumably apply to 21(1) 4 as well. It is that our construction would lead to a thoroughly uncommercial result, which would not eliminate the shortfall, quite the reverse. And
but that's just as I understood it, as I read it. Perhaps I'm completely wrong. It's just a reference to instead of creating a situation in which contributions are increased and recovered or paid back into the scheme, for example, actually what will happen is that everybody will run for the door. And that's why he says it's thoroughly uncommercial and should not and will not eliminate the shortfall. He's not talking about actuarial bases. I don't think it crossed his mind, did it?
He says later in the paragraph, in those circumstances, far from eliminating the shortfall, the Atos approach would lead to there being no actual reduction in the shortfall at all. Now that is just not correct on a correct reading of the rule. If there is value available, if I can put it that way, it sounds a bit impersonal. If there is value that can be put towards the shortfall under 21(1) 2, then it has to be put towards the shortfall. That's
that's something different from your 1C. It's still not talking about actuarial bases and whether the shortfall on the basis of Rule 21 can be seen objectively to be diminished or eliminated at once, and that's different from perhaps what GN 16 may be saying, etc. That's not what he's saying in 99. It might be a different mistake in that last sentence you referred to, but it doesn't go to your 1C, does it?
He has. May I just make the. Sorry, I wasn't. You may not. You may remain at the end of this submission thinking that I'm making a different point from the one that I thought I was making. But can I just give you the simple steps as I see it? We say that it was fundamental to it was part of his reasoning for saying that there was a discretion that if 21(1) 2 was applied according to what we say are its terms, it wouldn't eliminate the shortfall at all. And in those circumstances, if doing what the rule says you should do as an actuary isn't going to achieve what the rule says you should do and says should be achieved, then that's a thoroughly uncommercial result, and that's another argument for saying there's a discretion. And he clearly, in that sentence that I've highlighted, the penultimate sentence of 99, has misunderstood the effect of an increase under 21(1)(2), because if an increase is made, thereby contributing extra value to the shortfall, it will to that extent make the shortfall good for the purposes of this rule. So there is in fact purpose in doing it, and less reason to actually simply say, I don't think that's going to get us anywhere, I must have a discretion.
It doesn't seem to me to be what he's saying at all. He said earlier in paragraph 99 that operating 21(2) to the maximum, 130%, would, as matters now stand, that is, I assume if the 29 active members stay put, that would reduce the 18 million shortfall by 900,000.
Well, yes, that's what he's assuming. Yeah.
But if they all run for the door, then it won't reduce the shortfall by anything.
Well, the steps that the rule requires you to take, and the proper construction of those steps, mean that the shortfall will be reduced to the extent that there's an additional contribution and to the extent that there is benefit. Because the fact that they may run for the door subsequently is irrelevant. The rule is blind to what might happen in the future. It's looking at what happens if you rebalance. This rule is about rebalancing the contributions and the benefits to meet a required shortfall.
But 21(2) says nothing about benefits, does it? It's just increasing contribution.
Yeah, but the point still is valid. If to the extent that a contribution increase is determined under 21(1)(2), it will reduce the shortfall.
Well, why? Because the 29 and the 29 members have to give a month's notice, yes. And during the month they have to pay enhanced contributions. But after that, they're out of it, aren't they?
Yes. And the fact that they haven't paid the contributions that 21(1)(2) has said they must pay will then be picked up at the next valuation. And then there will be a shortfall, because rather than that stream of income coming in, it won't have happened. And it's not the same position as if you were looking at this on a deficit basis, where you would take all of that into account. But purely on the operation of the rule, that is the position. And where the rule says do this, and if you do it and you contribute value through a contribution increase, and you also reduce the shortfall by reducing or removing benefits, there isn't any room for actuarial discretion in that.
Sorry, at the moment you're focusing on the penultimate sentence in Chancellor's paragraph 99. Wouldn't be any actual reduction in the shortfall at all. But look, you may say, well, that's what the rule provides, too bad. I understand the argument, but why is he wrong to say that the Atos approach would lead to there being no actual reduction in the shortfall at all?
Well, because the question of whether there is a reduction in the shortfall is under the rule, it occurs at the moment that the contributions become payable and the benefit reductions take effect. That reduces the shortfall at that point in time. That's what the rule says. But the
benefits are only. Sorry, I probably think I'm terribly slow, but we're stuck on this point. It does seem to me to be an important one. if the active members opt out, then there is nobody left whose benefits are reduced, surely.
No, but at the time that the benefit reduction takes effect, the 21.4, those members were there. And the deal under this rule, the deal under the rules, whatever might happen separately under the statutory provision, the deal is that where there's a shortfall, you have to make it good through contribution increases and, if necessary, benefit reductions. And if you are an active member at the point where that moment in the life of the scheme comes, that is the effect of the rule. And that is why the sentence that I've highlighted represents a misunderstanding of what the commercial aim, if I can put it that way, of the rule is. He says that's an uncommercial outcome. The answer to 99, amongst other things, is that it's not an uncommercial outcome, because what the rule is trying to achieve is the injection of some money on paper through contribution increases at that moment. It's resetting the balance sheet, and it is also doing the same through making benefit reductions. Now that is the, if you like, the commercial purpose behind the rule. So if it operates in that way, that's not, as the Chancellor has said, an uncommercial outcome.
May I try to summarise where I think you are, so that if I go off the rails, you put me right?
Yes. I will try.
You're saying 4 follows 2 like night follows day.
Yeah.
That's where we were before the short adjournment. 2 and 4 are obviously to be read in the context of the words in Rule 21, and they take effect for the purposes of 21 immediately,
yes,
whether they actually lead to money coming in
yes,
at all.
yes,
Because the actuary looks at it and says, I've increased the contributions, or the contributions have been increased, let's put it that way, by X, and the benefits have been reduced by Y, and so I have a balanced situation.
yeah.
It doesn't matter whether that money comes in or not. He looks at it that moment on that basis.
Correct.
And that is why you say your 1C, which I think is, I have to say, I still find it follow, but you say, aha, if you do something different, what is implicit in 99, you say, is that actually you're looking at deficit in a different way.
Yes.
Whereas for Rule 21, it's a cut-off date at the date that those things happen. That's the difference. And therefore you say none of his thinking in 99 is relevant, and that leads him to discretion, because it's not thoroughly uncommercial. That's what the words say.
Yes, precisely. That is my answer to that.
Thank you.
And the what an evaluation under the Part 3 would make of the situation that my Lord Justice Bean is troubled by is entirely different, and would no doubt lead to some different result, but not in relation to the benefit reduction, unless the so in terms of the benefit reduction, I think what my learned friend was saying earlier was that we would expect that to have to be respected by the regulator, but we'll have to see what happens there. But just because this is the snapshot effect of Rule 21 at the moment that it takes place, doesn't mean that something else may not happen through the parallel process that overlies all of this. We're just asking the court to tell us if that is how the rule on its face operates. and that is the basis upon which we say the rule has been understood for many years, but clearly it's never been before the court, and this is the first occasion to consider it. My Lord, that's what I say about paragraph 99 and what I say about 1C. 1D I don't need to deal with, that's dealt with in our, it's the same point to some extent, but it's also dealt with in our skeleton, and it's a small point which I don't need to trouble you with. Yes, I can move on, I think. I'm moving to ground 2, which is construction of the word determines in 21.1.2. Much of my submissions on this have been made already, so I'm just going to take this relatively speedily. You will see that ground 2A and B are similar, and we in those criticise in particular the Chancellor's ruling at paragraph 97 in the judgment that the word determine in Rule 21.1, 2 and 4 do import a determination which involves the exercise of judgment and discretion. It's not clear to us on what linguistic basis the Chancellor reached that conclusion. We say that determine is, as I've said already, a thin word in itself. It embraces that there will be a process in which a conclusion is to be reached, a decision is to be made about something by someone. It says nothing in itself about how it is to be reached. Our case on Rule 21 at the bottom is therefore that the court needs to engage in an exercise of identifying the role of the determinations in Rules 2.1 and 2, 2.1.2 and 4, and in identifying that role, applying the meaning of determine only takes us so far, and that is not very far. That is the argument in our skeleton at paras 48 to 49, and we say it meets the judgment at paragraphs 114 to 115. The respondent's argument is based on the idea that determine must mean the same thing on each occasion in which it appears in 21.1, or at least within the same sub-provision, and that since it sometimes connotes an exercise of discretion, which we would accept, it must mean the same thing or connote a discretion on each occasion. And they rely in their skeleton at para 51.4 on what the judge said, the Chancellor said at paragraph 98 in his judgment. It's inherently unlikely that determine and determined would mean different things when used in the same provision in close juxtaposition. We challenge that for the reason that I've given. We don't say that linguistically they mean different things. We say that what determines means, and this is the wording that my Lord Sir Launcelot Henderson used this morning. It reflects what is in paragraph 49 of our skeleton. It means to decide a matter, and in itself that neither imports a discretion nor calls for a mechanical calculation. We say that we're in the territory marked out by Lord Justice Newgee in Britvic at paragraph 68. That is volume 4 of bundle D, tab 23, between 753 and 754.
So, paragraph 68.
Yes, and that's at page 753 in the bundle, where he says that more commonly there is no real dispute what a word means, but there is a disagreement about how it applies in the particular context. That's precisely our situation, we say. For such questions, understanding the context is therefore necessarily an important, indeed essential element in determining how the language is to be understood.
Sorry, where is that?
That's paragraph 60.
Yes, but where's the second part?
Sorry?
For such questions, yes, I got it.
You have it, my lady. Thank you. And then he refers in paragraph 69 to, in such cases, the language, either by itself or at any rate once read in context, can be seen to give rise to rival possible interpretations. And then to that he refers to the familiar tools and techniques are for construction in that situation, which I don't think I need to remind the court of. But it's what he says in 68 that we rely on. We suggest that what you might call textualism gives little assistance in construing the type of determination that is required in the two instances where it matters to the appeal. And as I said, one must try to ascertain what the determination actually requires. And if I can give an example of that in relation to the determination under the relevant determination under 21.1.2, the actuary is being asked to determine the amount of the increased contribution that can be generated up to the cap so that that can be set off against part of the shortfall. That is, if one looks at it, what the actuary is being asked to do. And that has absolutely no resonance with the concept of the actuary being able to import into that determination his own discretion as to whether or not the members will be able to afford paying the contribution that that calculation generates. Similarly, in 21.1.4, it mandates that benefits shall be reduced, and the determination that the actuary has is a determination of the basis upon which that reduction will be applied. That's what clearly in its context it means.
Sorry, what reduction?
The reduction in future service benefits.
No, I see that, but you're saying that in the closing lines of subparagraph 4, the actuary shall determine the basis of reduction of members' benefits in respect of future service. You're saying that implied are the words to the extent of eliminating the shortfall.
No, I am taking it from my here it is. Thank you. you start from the beginning, my lord, unless the Act determines that the remaining shortfall is trivial, if there's still a shortfall,
Yes.
after member and participating employer contributions have been increased, the benefits of members in respect of future service shall be reduced. That's the wording I rely on as identifying the task with which 4 is engaged overall. And that is, in context, we say the right construction, because this rule is about putting contribution increases and benefit reductions to the extent possible in terms of value, available value, towards making good the shortfall. And there is no wording that imports a discretion in the actuary in relation to the benefits shall be reduced. It is solely, in the actuary's case, a determination of the basis of reduction. That's the scope of his role in that at that point. Yeah, I mean, Leonard Jr. reminds me that this all goes back to the top, to STEM. 21.1, if evaluation shows that there is a shortfall, I'm paraphrasing, the last words, the shortfall shall be made good in the following way. And that flows through.
You say that the Chancellor was wrong to insert the words so far as practicable, that was based on a misconception, and that therefore it's simply mandatory, and therefore all the subparagraphs mean shall be reduced, calculated on such reasonable basis means shall be reduced to 0, and
or whatever amount of reduction is required to meet the gap in the shortfall.
Yes.
In this case, it would be 0.
Yes.
In another case, a few years ago, it might have been much smaller. But yes, subject to that, my lord. Yes.
And similarly, in the closing words of 4, the actuary shall determine the basis of reduction of members' benefits with respect to future service, easy, 0, on the facts of this case.
Yes, and there is a job of work to be done. If you reduce the benefits in a population of active members, I appreciate the active member population is relatively small now, but if you, this rule has been in force for nearly 30 years, and the way in which you would apply this reduction would be a task of some complexity.
So let's go back.
Active members have different benefits, and do you apply it pro rata across all of them, or how do you do it? That's a job of work to be done, my lord, and that is what 4 is describing the job of work of the actuary to be.
Because there are a bundle of rights, a bundle of benefits which will be of different kinds, lump sums, etc., etc.
Exactly.
And that you can reduce some and it will have a price tag on it, etc.
Yes.
But I was going to take you back because I'm puzzled about this whole discretion point. You take the Chancellor to task in relation to paragraph 97 of his judgment, where he says, as determined by the actuary, imports a determination which involves an exercise of judgment and discretion. And you use the term discretion in relation to some, or the possibility of it applying to some exercises which an actuary might have to fulfill. I'm using very poor language. But I'd just like to get to the bottom of what you say, and then you say it's all about context, but what you say the actuary is doing in each of these circumstances in 21. I would have thought before we go there that you would accept, and I'm interested to know, that the job of an actuary is not merely a number cruncher, and he's required to exercise his professional judgment. And he is entitled and expected to do that. That's his job. That's why he gives actuarial advice. He doesn't just produce a schedule of numbers and say, which one would you like to choose? So, with that in mind, and with context in mind, what do you say he's doing? What do you say the context means that determines means in little 2 and little 4? So in little 2, unless the actuary determines that the remaining shortfall is trivial, what's that?
First of all, he has to calculate what it is.
Well, he's done that.
Yeah, yes, I understand that, but I mean that...
He's done that under the STEM. He started out
Yeah.
by doing an actuarial valuation, hasn't
Yeah. Whether it's trivial, that is a descriptive word over which he will have to make a judgment about what he thinks trivial is in this context.
And so that's an actuarial judgment.
It's an actuarial judgment.
Okay. So actually, you probably don't say that the Chancellor was wrong when he referred to judgment in 97, just discretion.
Yes.
Okay. Then we go on, shall be increased, etc. Shall be increased in accordance with 3B and 3A by participating employers, close brackets, as determined by the actuary. So he's determining something about the increase in contributions. What kind of exercise is that?
That is a calculation exercise. The increase in the members' contributions in accordance with Rule 3B may and probably would involve some element of professional judgment about working out what the long-term rate is.
3A and 3B, professional judgment. Okay. But
once he's done that, and that will be something that is a rate that he may well already have in his pocket from having done the valuation in the first place that generates the shortfall, my lady.
yes.
Okay.
And then he calculates what's necessary to make up the
Yes.
difference.
Yeah.
Okay. And then we've got the 130%, a little further down. 130% of the normal long-term funding rate of the section, as determined by the actuary. Now, what that is looking back to him having done that, I assume.
Yep.
What kind of determination is that?
Well, there's an element that it's a professional judgment.
Yep. Okay. And then, last sentence, the actuary shall determine the rate and period. What's he doing then?
He is exercising a judgment over deciding what the period should be. Should he spread it over a lengthy period or a shorter period? Once he's done that, it's a matter of calculation to work out what the rate is, because he's got a lump sum.
Okay, thank you. I'm sorry to be so slow, but it's helpful, I think. Little 4, unless the actuary determines the remaining shortfall is trivial, so that's the same as we had in 2. If there's still a shortfall, benefits for future service shall be reduced, calculated on a reasonable basis as agreed, subject to actuarial advice. So that advice, yet again, is an exercise of professional skills in accordance with all of the guidance which actuaries are subject to, and advice in the circumstances.
And we say that the advice he's giving there is to the trustee and the employer how you should allocate these benefit reductions amongst the population of active members. That's the subject matter of his advice.
But that's not any discretion. That's an actuary performing a task,
Yes.
because he has all the relevant knowledge of the scheme, of the statutory overlay, etc., and he acts in accordance with proper guidance from his
Yes.
institute.
Some of his tasks involving judgment will be familiar ones or straightforward ones, and some might be more complicated. But yes.
And then, if you can't agree on a reasonable basis, then the last three lines, the actuary shall determine the basis. That's where we came in on this long exercise. And you're saying you've been unable to come to an agreement. You've got this basket of different benefits. They'll have different price tags on them, and you can see how they hinge together with each other, and he will determine the basis. What's he doing when he does that?
He is trying to make a decision about how to allocate the total amount of reduction across the membership that needs to be
And what's
made, and he will be looking at what benefits the members have, and in a less extreme situation where it is not a case of complete removal of future accrual, how you are there likely to be winners and losers? Are there bits of benefits that you can more fairly or appropriately reduce than others? In a case of complete removal, then there is virtually no decision to be made.
But let's assume, because we have to allow these words to have the power that they need to have in any circumstance. So let's look at there being some oil left in the tank, put it that way. When he's doing that, what exercise is that? Is that judgment, or is it?
Yeah, that's judgment.
That's not discretion, is it? Or is it? I don't know. I'm interested to see what you say.
No, because it has to be a reasonable basis, which means he can't just do whatever he wants. It's got to be a reasonable basis. I mean, there is judgment involved in that, but ultimately he has the power to make the decision as to what is the reasonable way to distribute the benefit reductions.
But if it's a discretion to weigh up various benefits and what is best, taking into account relevant and not irrelevant factors. I'm just making this up. And if that is the case, who controls the exercise of that discretion, and what are the parameters in which it operates?
That would be that ultimately it's controlled by proper purpose, and it's akin to the trustee.
But he's not a trustee.
No, he's not. But he holds power to decide how the benefit reduction should be allocated. He's only open to challenge. The control on him is only that he must take relevant matters into account, or irrelevant, and not take irrelevant matters into account on the task that he has. It's perfectly clear, I hope, on my submission, that this doesn't give him the opportunity to say, I don't think there should be any benefit reductions at all. I think that's just not reasonable. It's not open to him to do that, because this is all about the long-standing benefit structure, which means that your benefits can be reduced. if that's necessary to make good a shortfall.
Thank you.
I mean, since the whole focus of the exercise is on the long term, why is it illegitimate to look at actually not the long term, but the very short term, which is the virtual or indeed total certainty that the active members will opt out as soon as they're faced with the reality of the figures? I mean, and why does that suddenly turn into discretion rather than just a matter of actuarial judgment?
He will be undertaking his parallel valuation, looking at that, and that will affect that. But this method doesn't allow for that.
Well, that's what you assert, but I mean, we're going in a circle here, aren't we? Why are you saying it doesn't allow it?
Because the task is, well, I'm going around in a circle in the sense that I'm repeating myself.
But if you've got nothing to add to what you said, that's fine. And,
Yeah.
we'll take it or leave it.
The scope of the actuary's professional judgment or discretion
Yeah.
doesn't enable him to either not increase contributions on members because they are unaffordable. How you read that in, we do not understand. There is no wording that enables you, or nor does the task, more importantly, the decision that he's being asked to make, permit that level of discretion. Because if the actuary can, notwithstanding the requirement that increased contributions should be levied to make the shortfall good, up to 130%, if, notwithstanding that requirement, the actuary can just turn around and say, I don't want to do that because I don't think it's reasonable for the members to have to pay that, then that entirely frustrates the rule. First of all, there would never be any benefit reductions under 4 in that situation. Because any actuary, if he's given that discretion as to whether they should be made or not, would say no. What's the purpose of 4 in that situation?
Why would you say? Why would any actuary say no?
Because if the situation with which you are faced is significant increased contributions combined with loss of future accrual, that is not a situation which any active member is likely to want to tolerate. And so the actuary will. I'm sorry, my lord.
Doesn't it depend on the degree of the deficit? How many members are left in the scheme? In the early days, there might have been, I don't know, thousands of members in the scheme. You might have a particularly bad year. There's a shortfall, and it's proposed that for the next year, contributions will be increased, benefits will be reduced a bit, perhaps not to zero, and then we'll have another valuation in a year's time and see what it's like. And the members might not all make a dash for the door, but we're now in a position where it's common ground. There will be nobody left very shortly. But it doesn't seem to me, just reading 21(1), that it's necessarily dealing with a situation of a sort of run on the bank.
No, it's certainly not. I accept that. Back in 1994, that may not have been the situation that was contemplated, and it's there to cover any situation that arises where there is a shortfall. I do not wish
Carry
to
on.
go
Right.
any. I don't want to repeat myself,
No.
nor go around in circles. If I can assist you any further on that particular point in the morning, I will do so.
Right.
But I think for now it's probably sensible for me to move on
Yes.
in order to try and cover some other ground.
Yes.
I leave the question of different determinations in Rule 21.1 with the observation, my lady, that there are quite a lot of determinations even in this rule, more than the ones we've looked at, and the same process of having to decide what the context is and what the decision is that the actuary is being asked to make applies. I'm not going to go through them all.
It is interesting, for example, in 21.2, where the trustee has a discretion, it says so. In its absolute discretion.
Yeah.
Yep.
The Chancellor said, I think, that if the construction were as we had contended for, the wording, the relevant wording in 21.2 would have been the actuary shall increase the contributions, not an increase as determined by the actuary. And he said that that was an indication that that imported a discretion. But I think one could turn that point around and say, if there's a discretion, why doesn't it make it clear? Particularly as the scope of that discretion will be quite contentious in a situation where, as here, the actuary can effectively put all of the onus, save for on the case of the on the case of the trustee, the actuary can effectively put the entire onus on the employer, which is to depart from the shared cost nature of this scheme. It's not lockstep anymore. It's whatever the actuary thinks it's fair for the members to pay, and the employer picking up the rest. And that's quite a big departure from the structure, and we would expect to see that reflected more clearly in the wording of the decision that the actuary has to take if that were the case. Yes, right. So that's ground 2, and can I just flag up one? I'll try and deal with it quickly so you know what the point is. Ground 3A of our grounds of appeal.
Yes.
Which is on is in bundle A at page 82. In construing Rule 21, Chancellor gave excessive weight to Article 7, and he failed to give adequate weight to the fact that SCA sections might be created in which no protected persons with the benefit of Article 7 would be introduced into membership. Now, there is a point of construction here. There's a general approach to construction which goes as follows, that the SCA rules as promulgated by the RPS order are not restricted in their application to schemes with protected persons in them. they can apply otherwise than to protected persons. If there are any protected persons in a section or a scheme, then the protection order does apply. And any effect that has on the requirement to fund the rights of protected persons also acts for the benefit of the non-protected persons, because it's a pooled fund. That's the so-called new due point from pilots, which is referred to by the judge. And we don't dispute that at all. But it's entirely foreseeable on the structure of the protection order emanating from Article 4, which I showed you earlier, that one might have a section or a scheme with no protected persons in. In that case, the protection order would not be engaged and Article 7 would have no role. And one must construe Rule 21 and indeed all of the SCA rules with that in mind. Article 7 can't come to the rescue. What is to happen in the case of such a scheme? How does Article 21(1) work in that situation? Does that affect the view one takes of whether the actuary might have a discretion in the places that the Chancellor said he had a discretion? Because if there is a discretion, there's nowhere else to go unless and until you get to the already everyone opted out stage, and 21(1)(3) applies. And 21(1)(3) wasn't there in the first years of this scheme's existence. So the idea that the actuary, through his discretion, can yet further diminish the amount of money coming in to meet the Rule 21 shortfall would cut across the purpose of the rule, which is to try and make good that shortfall. That's the submission on how one should approach the construction of Rule 21(1). As to whether or not the Chancellor himself was influenced by this, I just flag up paragraph 101. It is perfectly clear that the Chancellor throughout saw the Article 7 as the knight on the white charger, and he says in 101, under the provision as originally drafted, if there were no agreement between the trustee and the employer to reduce benefits, then the balance of the shortfall would remain. Now that, on his approach to 21(1) construction, of course, the amount of shortfall remaining is going to be greater because of his exercises of discretion not to increase members' contributions and not to reduce members' benefits going forward. So it's even more of a problem in the presence of a discretion. But he says this is where Article 7 comes into play. I'll deal with correct construction later, but for the present, it suffices to say that Mr. Green was correct to submit that it was intended to provide protection to protected persons over and above that provided by the Pension Trust, and it was imposing contribution obligations on the employer beyond those imposed by the RPS itself. That may be taken to suggest that he considered that the idea that there was a discretion in the actuary was a more acceptable and more commercially appropriate or approach, given the availability of a sweep-up option under Article 7, which wouldn't, of course, apply in a scheme to which protection order did not apply. As I've said, it's very difficult to see the justification for such a discretion, and if one puts it in terms of whether that construction gives reasonable and practical effect to the provision, it doesn't in our submission, because it leaves the scheme even more underfunded because of the discretion. And I think that my other submissions on construction, reasonable and practical effect, and the Chancellor's serial expressions of view that our construction produced a thoroughly uncommercial result. You've already seen 99 and 104 have been dealt with in my earlier submission and also in our skeleton, and I won't trouble you further on those for now. That brings me to Article 7, which is the subject matter of ground 5 and 6. The essential argument is ground 5b. We accept that Article 7 provides some additional funding protection, because if the rules properly operated to the end of the waterfall, leave a gap after benefits have been reduced and after contributions have been increased, then on the wording of Article 7, there is a sensible construction route that gets you, I'll take you to the provision in a moment, takes you to the actuary having the task under 7.1 of ascertaining additional contributions to be made by the employer to make sufficient provision for the rights that are not otherwise being funded. However, the Chancellor's view of the effect of 7.1 was that it had the effect of overriding the final stage of 21.1.4. And that we do not accept, and we suggest that he was wrong in reaching that conclusion. Yes. It's paragraph 107. I'm sorry, my lords. This is clearly a duty above and beyond that under the scheme itself. I'll come to quite whether that's correct in a moment. It's founded on there being an existing duty to contribute under Article 7.1. But leaving that aside for a moment, and it is a sufficiency of funding or balance of cost obligation which will be to cover whatever amount in the opinion of the actuary is sufficient to make provision for those pension rights, having taken account of the resources of the scheme and any employee contributions, which suggests, in accordance with Mr. Green's primary case, that this provision kicks in after Rule 21.1.2 rather than after Rule 21.1.4, although it ultimately may not matter very much. That's because he's already said that there's a discretion. We beg to differ in relation to that. If that were the case, it's an example of the protection order not providing an overlay to fill a gap, but in effect creating a gap which it then fills, as a result of which a source of funding for the shortfall provided for in Rule 21.1.2 is not utilised as we submit should be.
But you've just said instead Article 7 creates the gap which it fills. Is that because, not of Article 7 itself, but because of the Chancellor's construction, which
Yes.
means that there's a discretion to start with, which is exercised at 0 or 1 or whatever, which creates the gap which Article 7 floods in to fill?
Well, I think he's saying more than that. He's not saying it only floods in at 7 after 7.2, if I'm right that there's a discretion, because he says it may not matter when it kicks in, given that it is a sufficiency of funding or balance of cost obligation imposed on the employer. He is saying, as we read him, that it displaces Rule 21.1.4. It says this provision kicks in after Rule 21.1.2 rather than after Rule 21.1.4. So it disrupts the working of the rule. And that, we say, is not the function of the protection order. There's no warrant for finding that is part of the function of the protection order. It goes beyond filling a gap that's actually there. And as I say, it has the effect of interposing and therefore creating a gap that it can fill. I think it's useful at this stage to look at Article 7.1 so you can see how the Bundle B.
Page 13. Oh, that's the Chancellor's text, yes.
It's tab 11.
145.
Page 145.
Is there any difference between this version and the Chancellor's version, except his interpolation of so far as reasonably practicable in square brackets?
Is there any difference between, in practical effect, between...
Sorry, no, not Article 7. Ignore
My
it.
interpretation was that the words in square brackets were in 21
Yeah.
rather than 7.
Yes, sorry.
I think.
Bad point, yeah. Okay, page 145.
Yes. And it needs a little care to follow it through. It applies, it's engaged where there is a person mentioned in paragraph 7.2 of Schedule 11 who is under a duty to contribute, and that would include an employer. I don't need to take you to Schedule 11, para 7.2. I hope I can tell you that.
Yes.
Who is under a duty to contribute to a section of an occupational pension scheme in which a protected person has relevant pension rights, or B, that's not applicable. So it's A that's applicable. And the contributions which that person shall make under that duty, those are the key words, shall not be less than such amount as, in the opinion of the scheme actuary, shall be sufficient to make provision in respect of the rights specified in paragraph 2, after taking into account all of the relevant matters, including the resources of the occupational pension scheme and or section and any employee contributions. The following rights are specified for the purpose of paragraph 1. First of all, pension rights which date in respect of which the scheme actuary gives opinion have been accrued under the scheme. That's straightforward. And B, any pension rights which are accruing in respect of current participation in that scheme or section. And C is not relevant. Now, first of all, the reference to under that duty, we say, is a reference to the duty of the employer under Rule 3 and Rule 21 to make contributions. So that means, if that's correct, that the effect of 7.1 is to deliver through that duty, to be engaged in relation to that duty, whatever it is that is deliverable under 7.1. And we say that that means that whatever the scope of that duty is, needs to be respected. And not ignored, disrupted, or interfered with. And you then see what the outcome of that duty playing out in the rules is. The outcome, we say, in the rules is that the employer and the members will have been will be liable for increased contributions under 21(1)(2). And those are future contributions which, in the case of the members, have to be brought into account. They're not contributions they're paying at the moment. They're the ones they're going to once the valuation, once the 21(1)(2) process is effective. And those contributions must be taken into account expressly under the concluding words of 7.1 and any employee contributions. But quite apart from my point about how under that duty requires the position to play out under the duty, and therefore that includes Rule 21(1)(4, there is the point that the rights for which the actuary has to assess sufficiency of provision and calculate extra contributions from the employer to meet are the rights that have already accrued. So that includes the rights of our current active members up to the date, and the relevant date is the effective date of the 21(1), 3 and 4 decision. And the reference to rights which are accruing is a reference to the rights that will accrue into the future which the member is going to be earning, for which some provision has to be made. And those cannot include the rights that have been abrogated by Rule 21.1.4. Otherwise, you would be recognising future contributions from members, but not recognising the benefits that they are supposed to be covering. This doesn't stop, obviously, provision being made under 7.1 for what may very well be the significant gap in the shortfall after 21.1.2 rule-based increased contributions and 21.1.4 rule-based benefit reductions. There's clearly going to be a gap in the sort of situation that we're contemplating in this case. And that would flow through because the duty's played out and it's not sufficient, it hasn't generated sufficient provision to meet the pension rights that qualify under 7.2. That's the textual construction with an element of purposive construction as well overlaid because of my submission that nothing in this protection order that warrants a conclusion that its effect can be to override, interfere with the contribution rule. This is a top-up provision, we say. This is our option B. As I said in my opening remarks, how the actuary would go about assessing the amount that the employer would have to pay is not a matter that we have to concern ourselves with. What assumptions would be applied, that's outside the ambit of this appeal. And that's why I'm maintaining some at least notional distance between my option B and whatever Mr. Green's operation of 7.1 is, because it may be that we would part company over the way in which it would operate. But however the actuary would operate it, even on any basis, we say it cuts in, it kicks in after 1.4 and not after 1.2. The Chancellor, with the greatest of respect, did not engage at all with the text of the relevant bit of the text under that duty. It is true that he did rely on the concluding words to 7.1, any employer contributions, but he didn't engage with 7.2b in his analysis of when it kicks in. And that, we say, was an error, because when one does engage in that process, the result is we submit as I've contended. That is ground 6. Although I do accept that we have reconsidered the constructional route that needs to be taken through Article 7.1 to explain option A which is not, as my learned friend defined, our preferred option. Option A, which is that which we put before the court previously, says that that duty is the duty to contribute under 21(1)(2 only, and that the actuary's role is to ensure that an appropriate amount is contributed in relation to that particular stream, if you like, of contributions. We accept that a broader view can be taken of the duty of the employer under Rule 21. The duty to contribute is a package affected by all elements of 21(1). In a situation where the valuation commenced after all members have opted out and 21(1)(3) is engaged, there would be a role for 7(1) in ensuring that the contributions payable under 21(1)(3) by the employer, which are balance of cost contributions on its terms, are actuarially appropriate to make sufficient provision for all of the rights that are to be covered.
Right, would that be a convenient moment to pause?
Yes.
Until tomorrow morning. We hope that you'll reach the finishing post by 10:45, give or take. May I point out, and this applies to both sides, that the Lady Chief Justice and the Master of the Rolls are encouraging courts where there are two counsel on each side, encouraging the leaders to consider whether the juniors might have a speaking role. But having sprung that on you, I just leave it. I see Mr. Steer is about to faint, but I leave that thought with you. But are we on schedule for you to hand over the baton to Mr. Green at about 10:45?
The timetable does provide for me to steal something from my reply time if I'm going to need it, and I think I may need less time for my reply.
Yes.
You'll have to make a judgment. We've spent quite a lot of time on what I would call opening the case, and I hope it's been helpful, but it means that some of my substantive submissions are being slightly compressed. So, I'm sorry.
It says the opposite. If you overrun in your opening, the reply is contracted. Not if you take less, you can take it.
No,
Well, as
that's what I'm talking about.
Sorry.
My Lord Justice Bean has asked me if I'm going to finish at 10:45. If I don't finish at 10:45,
if you don't finish
I'm
at
going to lose some time
10:45,
on my
then
reply.
within reason you can steal time from your reply. But you've both been in the business for a long time and have great experience, and you will
We'll cut my cloth, my Lord.
have a sense of, yes, there is also Parkinson's law of advocacy, is there not? But submissions expand to fill the time available, but they may also contract to fill the time available.
Well, I will take that on board, and the one thing I won't do is sit down and say to my learned junior and surprise him.
Over to you.
Over to you, which back in the day did happen.
Oh yes,
as you may well remember.
I well remember. All right, 10 o'clock tomorrow. Thank you very much.
have an argument about the construction of the time.